Welcome to the Essential Tax Podcast with your host, Mishkin Santa. In each episode, we'll take the complex world of tax, all the jargon, acronyms, and stuff that make your eyes glaze over, and explain it in an impactful way to understand the complex and unknown areas. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, thewolfgroup.com. Now, here's the host of Essential Tax Podcast, Mishkin Santa.
Hey everybody, I'm super excited for today's podcast because it touches on an area of law that is my second favorite. Tax law is my first. When I was in law school, I tried to take immigration law in my second year or third year, but it interfered with, I think, corporate tax. And looking back all these years later, I actually wish I had taken immigration law instead of corporate tax law because I honestly don't remember anything from my corporate tax law class. And I think I would have learned a lot from my immigration law class. But today's podcast is we're going to talk about the intersection between immigration and tax law, which is very, very important. There's a lot of times where people come and ask questions, and I have to say, well, that's really an immigration law question. And I'm sure our guest would agree that there are times where she gets questions that are, oh, that's more of a tax law question. But they intersect a lot, and you have to really understand that there is an intersection, and you do need a qualified person to kind of answer in the various camp of wherever the question falls into. But before I go down a rabbit hole, I want to introduce our guest, Becki Young. I'm so pleased to have you on here. Becki is a fantastic practitioner. We'll link her bio in the show notes. When you get a chance, look at it because she's got all sorts of accolades and very prestigious and whatnot. But Becki, why don't you tell the audience a little bit about yourself? First off, welcome. Tell the audience a little bit about yourself, education, background, licenses, practice areas, all that good stuff.
Okay. Thank you, Mish. So nice to be with you here on this podcast. So as you mentioned, I am the managing partner of the business immigration practice at Grossman Young Hammond, which is a boutique immigration law firm in the DC area. And I guess to start with my personal background, I have a law degree from Georgetown and have been practicing immigration law for about 30 years and certainly never a dull moment. They say that tax and immigration are the two most complicated areas of the law. So we have a lot of complex stuff, I'm sure, to talk about today. I'm a member of the American Immigration Lawyers Association and very active with that organization, which, among other things, has advocacy and governmental liaison. So that helps us to get a sense to the extent possible of sort of what the federal government is thinking with regard to immigration. Our law firm has about 20 lawyers who practice both business immigration law, which is my area of specialty, as well as humanitarian and Interpol law. So people sort of human rights and people who are politically targeted. And we also do outbound immigration. So we help people, which is an area of our practice that's been picking up. We help people who want to immigrate outside the United States. And we also work with complex consular inadmissibility, which is a long way to say people who are having trouble getting U.S. visas, as well as entry issues. So you may have read a lot in the papers recently about people who are concerned about what might happen on reentry to the U.S. So that's another area in which we work and which has really been picking up recently.
Fantastic. Okay, so today's podcast is going to be broken down into a couple different topic areas. We're going to talk about immigrant visas, non-immigrant visas. We're going to go into EB-5 and this potential new gold card program, which I've had a lot of people ask me about. I do want to talk about a hot button topic, which is slightly related to immigration, which is the proposed remittance tax on outbound transfers. And then I'm going to talk a little bit about IRC 7345 at the very, very end, which I don't think Becki has a lot of comments on that. But I do want to make sure, since we are talking about kind of inbound, outbound, leaving the United States, coming back in, I do want to make sure people are aware of that law because we've had some folks recently run into that with their passport getting revoked. Just very quickly as some background. So the Wolf Group, we're over 40 years old, and yeah, I like to tell people that one of our specialty areas is that you can ask us typically about any visa, immigrant, non-immigrant visa, and our staff should be able to tell you about the tax treatment of that individual, whether their days count for purposes of the substantial presence test, how a tax treaty would apply, how they would be taxed. And I've long wanted to do this, and the other partners won't let me do this, but I wanted to create a chart, like draw like a mural on the wall in the Wolf Group with all the various visas and kind of like write down like the different tax treatment of each, so that anytime we get a question about that, you can literally just go to the chart and say, okay, O1 visa, it would be this. G1 that, G4 that. So they won't let me do it though. I guess that's just gonna have to stay in my brain. But it's something that we're very passionate about. We like helping out people that have complex tax situations, and I think when it comes to especially the non-immigrant visas, it can be quite complex. But before we get in that topic area, let's start with the immigrant visas. And Becki, do you want to give us some background information on what is an immigrant visa typically and some of the things that you're seeing there?
Sure. And maybe as a preliminary matter, I can mention what's an immigrant visa versus a non-immigrant visa, because I think that's something that not everybody knows. And certainly I didn't know when I first started working in this area. So US immigration is divided into temporary visas and then permanent visas or green cards. So people who come to the US for a temporary period, like students or workers, will receive these non-immigrant visas, which we'll talk about in a little bit. And then people who want to immigrate to the US. So the word immigrant is someone who refers to someone who has a green card. And so people who want to live in the US permanently and have permanent authorization to work here would apply for an immigrant visa. So they're often done together. Many people have both sort of a non-immigrant track and an immigrant track, but it doesn't have to be that way. You could have a non-immigrant visa or an immigrant visa. So immigrant visas equal green cards, I think, is the best way to remember it.
Okay. And talk me through, you say that there's some preferences with the e-visa that are also within that immigrant visa status. Is that right?
Well, the immigrant visas in the employment-based category are actually called EB, so employment-based. So there's EB1 through EB5.
Okay.
And again, maybe the step back. So there are family-based visas. If you are the spouse of a U.S. citizen, for example, there's a whole category of family-based immigrant visas. And then there are also DV lottery, which is the green card lottery. There are green card visas. And then there are humanitarian ways to get a green card, like through asylum. But what I wanted to focus on, because I think it's probably most interesting to your clients and also my professional expertise, are the employment-based categories. We can certainly touch on any of the other categories if you like, but within the employment-based categories, EB1 is first preference. So those are the types of workers that we ideally want to bring to the US most. So those are workers of extraordinary ability. Those are outstanding researchers and also multinational managers and executives. So those people receive the highest preference in our immigration laws. They can typically process the fastest. They have the most preferential treatment. And EB1, extraordinary ability, is one of the two categories that allows for self-sponsorship. So we get a lot of requests from people who are very accomplished and they want to sponsor themselves. They don't want to have to be tied to a U.S. employer. So EB1, extraordinary ability, is a self-sponsorship category. The other self-sponsorship category is the national interest waiver, which is in the EB2, the employment-based second preference. So if you are doing work that's in the U.S. national interest, like a cancer researcher would be a great example, you may be able to self-sponsor for a national interest waiver. The employment-based second preference is for people with a master's degree or a master's equivalent. And so there's a non-self-sponsored EB2 option, which is through sort of the standard process called PERM. So EB2 could be an employer-sponsored PERM or a self-sponsored national interest waiver. Then EB3 is for skilled workers and other workers. That has to be employer-sponsored. EB4, I think you wanted to hear about that a little bit. So that is special immigrants, which includes, among other people, G4 retirees.
Ah.
And That category, until, I don't know, maybe 5 or 6 years ago, was always current. And so that was a great option for people who worked for the World Bank and other international organizations. There's a provision that allows them to retire in the United States after a certain number of years of service. And I won't bore you with the details, but the Department of State made a calculation error, and that resulted in that category being backlogged to the extent to which it's really no longer a practical option. The backlog in the EB4 category is currently estimated at about 20 years. So I can explain how backlogs work, but long story short, the EB4 is a very, very, long wait. And because the G4 retiree provision is for someone who's at the end of their career, most of those people may not have 20 years to wait for a green card.
Wow, I did not know that. That is crazy.
It's I say those words a lot these days, Mish. That is crazy. But yeah, that's truly crazy. And again, like, probably a category of people, at least in my opinion, that we should be encouraging to remain in the United States. But that's the situation. Let me talk about the last employment-based category, which is EB5. So that's the immigrant investor green card, the current immigrant investor green card, where you can invest either in an government-approved regional center, which is what most of our clients do, or in your own business. So that's the investment of in the range of $1 million that currently exists in law. So those are the 5 EB5 categories. If you'd like, I can talk briefly about priority dates. I mentioned sort of how that works with EB4, but basically each of these categories gives you a place in line. And depending on a variety of factors, your wait may be longer or shorter. And, it could be 0 days, or it could be 20 years or longer.
Give me all the priorities. Let me hear the priorities. This is interesting knowledge.
Sure. So the State Department publishes something called the Visa Bulletin. And so if you Google Visa Bulletin, you can find this document. And it's broken down by family-based priority dates, employment-based priority dates, and then DV lottery, so green card lottery priority dates. And so if you are, let's say that you want to apply in the EB4 category, you could go to the Visa Bulletin for June, and it's a chart basically that lists the country that you're applying from and then the category that you're in. And so when I go to employment-based fourth preference for the month of June, it says U, which means unavailable. So that basically means the wait is not just 20 years. It's actually completely not, you can't, apply at all in the EB4 category right now. If we look at EB1, for most of the countries in the world, that says C, which means current. So if you're, for example, from Canada and you're an alien of extraordinary ability, you file a self-filed green card, you would be immediately eligible to apply for a green card. If you go across that, you can see that for someone from India or China, it's backlogged to 2022. So that means if you're an Indian or Chinese first preference immigrant, you would have to wait. It looks like 3 years, but that's the other thing I wanted to mention, is that 3 years in the Visa Bulletin is not 3 years in real life. So it means that if you applied in 2022, you can file for your green card now. But depending on how many people sort of applied in the interim and how many people are in the backlog, it might take more or less than 3 years. So, for example, Indian EB2 is January 2013. So that looks like 2 years, but I can tell you in real life, it's probably more like 30 years would be my guess. It's Indian EB2 is probably the longest and EB3 as well. So Indians have to wait decades to get to the point where they can file for their green card. So anyway, the Visa Bulletin, you could spend days probably analyzing the statistics behind it. But basically, if you Google Visa Bulletin, you can see the chart. If you take a look at the category and the country you're from, you can see approximately how long your wait would be to get a green card.
Okay, I got a whole host of questions here. So question number one.
Okay.
How often is the bulletin updated? Is it pretty up to date? Like when you log
Monthly.
Monthly? Okay. Number two, based off of what you're saying, you could go into now EB1 through E1 or EB1 through E4. Those are not green cards, right? It's just the number 5.
No, these are all green cards. So
They're
EB1
all
through
green
EB5 are all employment-based green card categories.
Okay. All right. Taking a step back, are there other visas? So let's just say I'm trying to get to the green card. Do you recommend that people start with one of these 5 first and try to go that route? Or is there another way that you would go, maybe a non-immigrant visa, then up to the green card? Like, is there other circuitous paths that are recommended to people?
And that exactly is what I was saying earlier, that the non-immigrant visas and the immigrant visas can be run on parallel paths. So it is possible just to go to the green card. And I would say, like, if I'm looking at the visa bulletin right now, the only categories that are current are employment-based first preference, and then part of the EB5, and that's for countries that don't have a backlog. So the backlog countries are China, India, Mexico, and Philippines. So if you're not from one of those countries and you're applying an EB1 or EB5, you may not need a non-immigrant visa because you may be able to get a green card pretty quickly. But everybody else, if you want to be in the US during the process, you're going to need a non-immigrant visa. Some people don't care. They're like, okay, you know what? I'm going to wait in my home country for, 3 years or 5 years or however long it takes to get the green card. But almost everybody who wants a green card wants to come to the US and wait in the US. So in that case, you do need to get a non-immigrant visa while you're waiting in the US. And I know you had, Mish, listed out some specific non-immigrant visas that you wanted to talk about. So the first group were the treaty investor and treaty trader visas.
Yep.
Shall we talk about those?
Yeah, absolutely. Go for it.
Okay, great. So the treaty investor is the E2 and the treaty trader is the E1. And the first thing that you need to know is that you can only get one of these visas if you're from a country that has a qualifying investment treaty with the United States. So if you Google E2 or E1 treaty countries, you can find on the State Department's website a list of countries that have treaties. So one, I guess, important group of countries that do not are the BRICS. So Brazil, Russia, India, and China. None of those countries have e-treaties. So the e-visa is not going to be an option for anyone from those countries. But if you're from most Western European countries, a lot of Latin American countries, Canada, Australia, most of East Asia, there are a lot of those countries that do have investment treaties. So the first thing you have to do is be sure that whatever country you're from has a treaty. And I will mention one point, which is kind of obscure, but I suspect it might come up with your clients, which is that there are some Caribbean countries that have e-treaties and also offer citizenship by investment. And so for years, that was a good option. But now there's a special provision that says if you got citizenship by investment, you have to live in that country for a certain number of years. I think it's 2 or 3 years before you can apply for an E2. So it used to be that sometimes people, especially high net worth individuals, would get citizenship in, like, let's say they're from Brazil. They can't get an E through their own nationality, but they would get citizenship in an E treaty country and then apply that way. That path has been sort of closed. So just so you're aware of that.
Okay, so they're catching the loopholes. I was going to ask about that. Like, one of the questions I was going to ask was, if I'm in one of these countries where, like, if there's a big backlog, or we're not, you're not like China, right? Like, do I just go get my Australian citizenship? I don't even know if it's possible to be a dual Chinese Australian citizen, but could I then apply through my Australian citizenship or some kind of secondary citizenship, or just does the fact that I have that Chinese citizenship then make that an issue?
So the chargeability for green cards is actually based on your country of birth. Okay. So you can't overcome that by acquiring a second citizenship, wherever you were born in the world is where you're charged. And as you can imagine, that creates some perverse results sometimes. But that's it for green card purposes. For the E visas, you can use an acquired citizenship. So, for example, if you, a lot of people have parents with 2 different countries, and so if you acquire citizenship through birth or ancestry or your relatives, that would be okay, and you could use that citizenship. You just can't use a citizenship that you acquire through investment. Okay. We had a really interesting case with a client who was a dual Canadian-Italian citizen. And when she initially applied for the e-visa, she wanted to apply as a Canadian because she'd lived in Canada her whole life. And she identified, I think, primarily as Canadian. And so we filed for her as a Canadian treaty investor. And then she decided she wanted to start sponsoring Italians. So that's another important aspect of the e-visa. You can get an e-visa for yourself if you're an investor or if you're involved in import-export, if you're a trader. You can also bring employees, but only from the treaty country. So if you're an Italian E, you can bring Italian E's. And so that's what happened with this client. She wanted to start sponsoring Italian E's. And so we revised her treaty company registration to convert her to an Italian treaty company so she can now sponsor Italians. So that was a fun case to work on.
That sounds fun. As a quick reminder to the audience, just so that we can intersect some tax in here, E1, E2, if you come on one of those visas and you're physically inside the United States, the substantial presence test is running. You could become a tax resident. If you are working and you're employed, not only do you owe federal and state income tax, but there's there's the Medicare, Social Security taxes as well too. All that jazz will apply. You're not a unique special butterfly or snowflake. You will be treated just like everybody else in the U.S. All right, Becki, back to you. Tell us some more non-immigrant visa.
Okay. And actually, I think that it's important that you interjected about taxes for ease, because I will say this is a visa that high net worth individuals use sometimes when they don't want to meet the substantial presence test. So there is no minimum amount of time that you're required to spend in the US if you have an e-visa. So if you purchase a business, you do have to, as the owner, direct and oversee the business, but that doesn't mean that you have to be in the US full-time or even half-time. So if you're actively involved in overseeing the business, these days a lot of people can oversee their business from anywhere in the world. And so you could hold an e-visa and still limit your tax liability. And obviously you would want to, speak with a tax consultant about how to do that. But that's a fact pattern we see a lot.
Yeah. Briefly, let me just intersect on that for 1 second from a tax perspective. So some people will not want to disclose worldwide income, worldwide assets, which is completely understandable. But just as a reminder to the audience, if you're going to take the route, we're going to be treated as a non-resident alien, but you're an owner of a business inside the United States. You're basically into 3 different flavors. It can be a C corporation, partnership, or disregarded entity. If you're a C corp or disregarded entity, you're going to have to file, if you're 25% or more owner, you're going to have to file the form 5472. Failure to file that's a $25,000 penalty. If you're in a partnership, there's non-resident alien withholding that is quite significant, and that could also trigger a non-resident return, which is a 1040 NR. So you may be jumping out of the frying pan and into the fire, depending on which way you kind of do that. But just beware that the analysis doesn't just stop because you don't satisfy the substantial presence test. You could have effectively connected income or non-effectively connected income that then has to be disclosed to the IRS. So, all right, Becki, enough tax. Back to the immigration.
All right, very good. Well, and you know what? I think you could also address that concern. Again, this is all very fact specific. Immigration is always fact specific, and I'm sure tax is as well.
Yes.
But as I mentioned, you can get an e-visa as the employee of a company. So sometimes someone might not want to own the company. They might want to have someone else own the company and employ them. And again, the E2 doesn't require you to be a full-time employee. It doesn't require you to spend any particular amount of time in the US. So there is some flexibility in the e-visa And actually, most non-immigrant visas don't necessarily require you to spend any particular amount of time in the U.S. And maybe that actually is an important point with regard to the green card. So, you could have an H-1B visa that's intermittent, meaning you spend, only a few weeks or a few days or whatever per year. You could have an L1 intercompany transferee visa that's intermittent. You can't have a green card that's intermittent. So if you don't want to spend the majority of your time in the US, you should not get a green card. And I'm sure, we didn't talk a lot about that, but I'm sure that's something you probably consult with people a lot. When we have somebody who wants to go from a non-immigrant visa to a green card, we send them to the WOOF group, because then they really need to think about, do I want to spend the majority of my time in the US?
Yeah, I always tell folks the green card's like gravity. It's going to suck everything in. You're going to have to be inside the US, or even if you go outside the US. We have some people that win the lottery that just come in, grab the green card, and go back. And they want to file a treaty tiebreaker because they're in a treaty country, because they don't want the exit tax clock to start. It's a whole deal. But I mean, it's going to suck everything in. There's going to be a lot of reporting that you have to do, that you need to consider. There's whole pre-immigration tax planning, and no one ever comes to me 6 to 8 months before that happens. They always come to me 6 to 8 months after it happens. And once you trigger the residency start date, it's hard to undo anything. I can't wave a magic wand and say, oh, we don't need to report this, or we can clean that up. It's then we're dealing with the facts and circumstances kind of after the fact, which sometimes doesn't lead to a good result.
Well, and I know we're headed in the direction of non-immigrant visas, but I think an interesting point with regard to citizenship, and I know that we've had some conversations with our firm in the WOOF group, when somebody is a U.S. citizen who maybe has lived outside the U.S. for most of their life, and maybe hasn't met their tax obligations, and then they want to move back to the U.S. or perhaps sponsor someone for a green card, sponsor a relative, that can become a big kerfuffle from a tax perspective.
Absolutely. And there's a lot of people like that. There's a strong push. Actually, we're talking here. It's May 29th, so it's right after Memorial Day. The House bill has passed. It's going to move to the Senate, the tax bill. I've heard that there's a new acronym for it called OB3, which makes me think of I'm just how old I am. I'm thinking about Obi-Wan Kenobi in Star Wars when people say that. But there's a strong push. I don't think it will go through, because it would add cost to the bill. There's a strong push for residency-based taxation. So switching from worldwide taxation to residency-based taxation, which would mean the people you're talking about may not have a lot of the issues that they would currently have, which is not filing the tax returns, not reporting worldwide income, worldwide assets. But certainly the cleanup process for that, I think, is super important to be able to get back to what you're trying to do, which is the sponsoring of someone, or trying to move the needle on an immigration matter.
Yeah, very interesting. Let us talk about green cards. So I know that you had a few more questions about green cards. I don't know if you want to cover those. You'd asked about sort of processing times, and also challenges that people have in re-entering the U.S. Should we talk about those?
Yeah. So for those that have been living under a rock since January 20th, there have been a ton of executive orders and a lot of propaganda put out that for those people that are not U.S. citizens, and I think even for U.S. citizens, some U.S. citizens have a little trepidation about traveling. They're worried about leaving the U.S. and traveling to a foreign country and trying to either come back in or having issues with coming back in. So certainly I would love to hear your thoughts about that, Becki. I think some people have told me that they get a G28 from their immigration. Is a G28, is that the right term? A G28. Yeah. So I'd love to hear you talk about that as well. And then I've heard all sorts of stories about the timeline for the green card application. Would love to hear you talk about that. And then extending the green. So once you get through the 10 years, kind of extending that as well. So I'd love to hear about all. I know that's a lot, but I think you're well prepared to speak on all four of those.
Let's start with entry issues, because that, along with outbound immigration, that's probably been the biggest area that our legal practice has picked up since January 20th. There are a lot of people who have concerns about re-entering the U.S. citizens, legal permanent residents, people on visas. Most of the people that we consult with in our business immigration practice don't have a lot of serious issues, but our firm definitely handles also cases where people have criminal issues or Interpol warrants. So those folks obviously have a much bigger reason for potential concern when re-entering the U.S. But we have a few questions that we ask people when they want to consult with us about their concerns, and one is interactions with law enforcement. So if you do have a criminal record or you've been arrested, that would definitely be a major area of concern in the current environment, regardless of whether it was resolved, years ago or not. That's something I think that everybody traveling should speak to an immigration lawyer. If you're a green card holder or non-immigrant visa holder with a criminal background, that's a big red flag right now. Political activity is also something that we ask about. There have definitely been, you probably saw the announcement yesterday about Chinese students.
Yeah.
The administration says that it's going to aggressively start revoking visas of Chinese students. And they had already started student visa revocations about a month ago. They're using AI data scraping, so sort of going out onto the internet to see, whether people have had criminal interactions. So, in some cases, those criminal interactions might be a conviction, which might be serious, or it might be a traffic stop. So it could be something very, very small or very big, but, any sort of law enforcement interaction is relevant here. Any sort of political commentary that might be critical of the current administration or supporting political causes that the current administration does not support. We've seen that can impact people's immigration status and their reentry to the U.S. So we do ask about that.
So let me ask you a question. Let's just say I have a Facebook account and I'm not making any political statements, but I'm friends with someone and they're posting political statements. Am I worried about that? Because there's a lot of hubbub about like, they'll take your phone and they'll look through what's going on. And then if they see, well, you're friends with so-and-so and so-and-so said this on your Facebook feed, and again, you're not the one saying it. You're just happen to be friends with that person. How concerned should people be? Should people delete their social media apps and recoil from that?
Yeah, it's a really good question. I have to be honest, I have not been using Facebook myself since November.
Okay.
I would like to say that you would not be held responsible for statements by your associates. There was actually a case during the Biden administration where I think it was a Harvard student had their visa revoked because of statements that they had maybe liked that someone else made on Facebook. So I think the AI data scraping is somewhat imprecise. I don't really pretend to know how it all works, but if they go out there and they look for Becki Young pro-Palestine and they find connections between me and causes whatever that that they consider to be problematic, it could be an issue. So I would not like to say that that's the case, but we've seen things which suggest that people should be very cautious in what they are posting on social media.
Okay.
It is an issue. Other points, prior immigration violations and overstays, what country you're from and what countries you visited, countries like China, Syria, Cuba, North Korea, etc., or Libya, are countries that could cause concern if you have stamps from those countries in your passport or you're from one of those countries. Russia. Also, whether your employer is of interest to the administration, so journalists, lawyers, or anyone associated with individuals. You may recall that the administration has issued executive orders targeting specific law firms or other individuals. So connections to those individuals could potentially be red flags. Having lost your passport also, strangely enough, but if your passport ends up in the hands of someone unsavory, that could be tied to you.
Oh no,
So,
I'd not even thought of that. So that's that.
yeah.
Wow.
I mean, it's certainly not fair, and I think, hopefully if this happened, you would be able to sort it out, but there are definitely cases of false, identity, and, like stolen identity. If someone takes your passport and steals your identity and then commits a crime, that could potentially cause problems for you. So these are all things, it's hard to know how cautious to be, and I'm not saying that, anyone who's ever visited Cuba will not ever be able to re-enter the United States. Just in an abundance of caution, I think that those are things that people should think about when they're thinking about re-entering the United States. And, U.S. Customs you don't have a right to a lawyer in secondary inspection. So when you re-enter the U.S., you go through that line of CBP agents, and they either let you into the country or they say, Mr. Santa, I'd like you to step into this room so that we can, have a talk. If you get into secondary inspection and frankly in primary inspection, you don't have a right to a lawyer. So even if you have a G28, you're not guaranteed that you can talk to your lawyer. There have been
So
occasions.
just real quick,
Go
what is
ahead.
a G28, just for the audience so that they
So a
know?
G28 is a notice of representation. So if you engage my firm and you engage me to represent you, I can provide you a G28, which says that I'm your lawyer, but that will be more or less helpful depending on the context. So in context where you do have the right to a lawyer, like if we make a filing for you, if we file for a green card, we're going to submit your G28 so that you can, so that USCIS will know that we're representing you. But at secondary inspection, you don't have the right to a lawyer. Occasionally, we are able to communicate with someone or communicate, with CBP when someone's in secondary, but there's certainly no guarantee of that. And so, it's important for folks to be prepared ahead of time. If you are detained, so when you get to secondary, you will either be released or you will be detained. Once you're detained, that's when you do have a right to a lawyer, and that's when the G28 definitely becomes relevant. So, folks who do have travel concerns along the lines of the list that I mentioned, and again, like it's not like if you made one pro-Palestine protest, post in your life that you need to start panicking. But if you feel like, there might be a real concern, it's a good idea to consult with a lawyer before you travel. And yes, to get a G28 if there's a possibility of detention.
Okay, side question here, because I get this all the time. So in the US tax code, there's a provision where an individual could be what's called a long-term lawful permanent resident or a long-term green card holder, meaning they've held the green card at any point in time for more than 8 years, which you have to use IRS math. And I always tell people, if I get my green card on December 31st, 2024, that's 1 year. January 1st, 2025 is 2 years. So real quickly, you could have held the green card for 2 days and already be 2 years into the eight year process there. But the question I get is for folks that have held it for a really long time, can someone revoke or pull their green card in what you're talking about, that primary or that secondary review when they're coming back into the United States? The way I read it is that they would still have to go before an immigration judge and before the green card is judicially revoked or abandoned. And I just want to make sure that I'm not missing anything there.
Yeah, that's right. So when you come back to the port of entry, if they find that you have abandoned your green card, or that you have, for whatever other reason that they want to take away your green card, they might ask you to voluntarily abandon your green card.
Wow.
And it is possible to do that either by your own choice. And sometimes they'll say, look, you're really not living in the US anymore. We'll admit you as a visitor if you sign the statement to give up your green card. You should be aware that you want to do that before signing that statement. Obviously, lawyers generally recommend not signing that statement, but I could imagine there are circumstances under which someone might legitimately want to give up their green card. But for the most part, you don't want to give up your green card. However, if you don't give up your green card, then you will typically be placed into removal proceedings, and you have an opportunity for a hearing where you can explain why you should be allowed to keep your green card. So that is fine, with the caveat. I was just telling someone this story yesterday. I had a client who was an active chemotherapy patient, and he came to the United States from his home country intending just to come for a brief trip. They said, you don't live here. You have to give up your green card. He said, I don't want to give up my green card. They said, fine, we'll issue a notice to appear and put you into removal proceedings. The next day, he regretted it. He wanted to give up the green card, but you can't do that once you're in removal proceedings. And so he got stuck here in the US for like 6 weeks, missing his chemotherapy treatments. And once you're in removal proceedings, if you leave, you self-deport, and that has all sorts of immigration consequences. So he was stuck here. He didn't want to stay here, but he didn't want to self-deport. And so, I guess my advice would be, if you are a permanent resident and you have any doubts about traveling into the US, whether you're going to be able to keep your green card, you should talk to a lawyer ahead of time to get some advice about what's the best course of action.
Absolutely. And just a clarifying point, the form you said that they try to make you to sign to give up the green card or the statement, is it just a statement, or is it the I-407, or is it a combination of the two? Do you know?
That's a really good question. I don't do a lot of cases where people are asked to abandon their green card at the port of entry. So it might be the I-407. It might be a different form. I'm not sure. But if they ask you to sign a form giving up your green card, please be prepared to decide whether you want to sign that or not in advance.
Yeah, so just so the audience is aware, if you voluntarily give up your green card and you've held it for more than 8 years, or it's judicially abandoned or somehow administratively abandoned, you will trigger the U.S. exit tax. It doesn't mean you're going to have to pay the exit tax, but the exit tax will apply to you. And then you're going to have to work with me or someone like me to walk through what that looks like and whether that will apply. So that's the big elephant in the room there. Okay, let's move on. And since we're on the topic of green cards, I want to get back to the non-immigrant visas, but before we do that, I want to talk about, and I don't think the website is up yet, but I want to talk just briefly about the potential, because I get this question a lot. And there's a lot of people that really want the gold card. And I'm in my head, I'm like, and we kind of talked about this before we started the podcast. I'm like, wait a minute, that's got to be passed by Congress. Like, only Congress can do that. And there's tax and there's immigration rules that have to be created. I don't understand how the administration, the executive branch could just create that out of thin air. Talk to us about that. What is that? What is the website? What's happening there?
So I guess I don't have, I would say we're getting a ton of questions about this gold card as well. So the idea of the gold card is that you pay $5 million. And so the EB-5 requires you to invest about $1 million to create a business or invest in a business that creates 10 jobs. And so it's an employment creation visa. The gold card would not require you to create any employment. And another important thing about the EB-5 is it's an investment. So your funds have to be at risk, but if you pick a good investment, you will get your funds back, typically with some interest. It's not usually a high amount of interest, but you get your money back for the EB-5. Or you should get your money back for the EB-5. For the gold card, you're just gifting $5 million to the U.S. Treasury, potentially, without tax liability. I think those, there's been a lot of talk. I don't know if anyone really knows what this gold card will look like. They had promised that it would be, finalized like 2 or 3 weeks ago. The latest I saw yesterday was that it was supposed to be finalized as of the 28th, which was yesterday. The website is still not up. We keep hearing rumors from our clients that, it's really happening. As lawyers, we don't know how it could really happen without Congress being involved, but I guess we'll have to wait and see. And the website that they provided is trumpcard.gov. So, you guys are welcome to check trumpcard.gov and see if that website becomes live and get more details there. The EB-5 program is designated through September 30th of 2027. So the president has said that he wants to get rid of the EB-5 at least until September 30th of 2027. The EB-5 program should be solid, but after that, who knows?
Yeah, it could be the gold card. Yeah, I've tried that website, and I'll quote the Jerry Seinfeld from the B movie. It's the long road to nowhere. So we'll see where that eventually ends up at. But what I've read about the gold card program from a tax perspective is that potentially you could create a carve out for just those folks, kind of similar to the G4A1, where they maybe don't satisfy the substantial presence test, or more importantly, it's kind of like a non-dom, which is more of a UK, European type of tax, but it's a non-dom regime, non-domiciliary regime. So it limits the taxability of the people that are paying the 5 million. So you could have a lot of really high net worth individuals coming in, not being subject to worldwide taxation, not being subject to worldwide informational reporting, subject to tax on U.S. source income, because that was specifically stated in there. Like if you make income in the U.S., you're paying tax. You're a good taxpayer. But yeah, that's what I've again. What's interesting is you've got the OB3 in the Senate next week, and maybe they add a provision in there about the gold card to kind of intersect that. And I think they'd have to also update the immigration code as well. But that's where I think it would have to go.
Yeah, I think we're all watching anxiously with bated breath to see what will happen with regard to this gold card, but I don't have an inside track on it right now. Just a lot of rumors that I'm hearing from every direction.
Okay, great. Let's briefly talk about the non-immigrant visas. At the Wolf Group, we have made our name specializing specifically on A1, A2, G1 through G5 plus NATO. I think everyone knows, like, if you have that, you come see the Wolf Group, where that's the way it's been. It's the way it's always been. If you're interested to learn more about that, go back and listen to the first podcast I ever did with Len Wolf and Bob Len, the founders of the Wolf Group. They'll talk to you about all their shenanigans with the World Bank and IMF back in the 80s, and how we kind of got to where we're at today. But when I think about non-immigrant visas, those are the first ones that come to my mind. Then after that, it's the FJM visas, which I think you briefly talked about, the prohibition of the F visas for Chinese students, and then the H-1B LO. But just kind of give me your thoughts on that. And then also, I'd love to hear, we have a lot of G4 visa holders. So those that don't know what a G4 is, it's an employee of an international organization. And they've had a heck of a time going from G4 to green card. Recently, basically, I think the process takes forever, or it's not happening at all. So I'd love to hear your comments about that as well, in regards to the G4 visa holder.
Okay. So let's start with A and G's. So yeah, as we talked about earlier with regard to the visa bulletin and priority dates, the wait for the EB4 category that the G4 green cards fall into is estimated at about 20 years. So that's a long time to wait for someone who's already at retirement age.
Yes. So that's a
I would
complete
say
no-go. Like, are you saying you wouldn't, a G4 comes to you tomorrow and asks you to represent them getting the EB4, you'd be like, no way, Jose. What's that?
I mean, we would advise the client of the timeline, and that they would need to find a different way to stay in the US during those 20 years if they want to stay in the US.
Mm-hmm.
And if the client was willing to assume that risk and willing to wait, we would take on the case, but we would definitely make it very clear. So it's not an impossible case. I mean, the case will move forward. It just takes more time than almost any reasonable person is willing to wait.
Okay.
I would, definitely, we're doing a lot of consultations with G4 retirees who've been counting on this provision their entire career and now find themselves not able to count on the provision. And so we're looking at different alternatives. The good news is that the self-sponsored categories that we talked about, so the extraordinary ability and the national interest waiver, do apply to a lot of people that work at the World Bank and other similar organizations. So those people do tend to be at the top of their field or doing work in the U.S. national interests. And so those are two categories that we frequently will divert someone, if they had been planning to use the G4 retiree, that's a lot easier than doing an extraordinary ability or a national interest waiver, but those alternative categories are available.
Sounds like you're having to be the MacGyver of lawyers when it comes to trying to shepherd those people over to the green card status.
Yeah, we've been doing a lot of MacGyvering these days, really trying to understand what options remain available to folks. So the A visas are for diplomats, G are for international organization employees. Our law firm doesn't get as involved in helping people move to those statuses because the embassy or the international organization has an office that processes the visas, and they typically won't work with members of the private bar. So we don't do that work a lot. What we see more often is people who want to change status from G or A to another status. And that's something that we do handle. There's special forms that are required to release your privileges and immunities, but it's basically a pretty straightforward process to change from A or G.
Yeah, just real quick on that. The revocation of privileges and immunities, that's a document that you have to sign when you're applying for the green card, correct?
Or the change to another status. So if you want to change to a visitor status or a work status, you have to give up your privileges and immunities.
Okay, so we were talking about the waiver of privileges and immunities, and I was just kind of mentioning, that's a critical thing related to the G4 visa, and that we were talking about that would change once you sign that. That kind of changes the taxability of certain income for not only green cards, but and you made the great point of that if you had other visas, it's applicable there as well. And then I think you were going to you were wanting to talk about other non-immigrant visas.
Yes. So maybe the next category of visas would be F, M, and J. So those are student and exchange visitor visas. They kind of all fit into the same category. So typically you don't get involved with DHS with those visas. So if you're a student, the school issues you what's called an I-20. If you're a J1 or if you're an M, the school issues you a form. If you're a J1, you get a form which is called a DS 2019. And so the Department of Homeland Security is not involved. It's the State Department that issues that to you, and then you take it to an embassy to get a visa. There's been a lot going on with foreign students, and also to a lesser extent, it impacts J's. So the announcement yesterday that the administration is going to aggressively revoke visas from Chinese students, I think is something that, we will be seeing in the coming weeks. We've already been seeing visa revocations, not just for students, but for various individuals. If you've been following the news about Harvard University, the administration took away their ability to sponsor F and J students. That was restored by a court. There's been more sort of activity about that, but the government does have control over the ability of schools to issue student status. So there's a lot of controversy over international students right now. And the social media issues that we talked about earlier, I think are especially pertinent to students. There have been some very high profile arrests of students, largely based on their on-campus activities and sometimes on their social media activities, often relating to support of particular political causes. And so, I think those particular groups of people, because they tend to be younger, maybe more active, especially F1 students, tend to come from China or India. China's really in the bullseye right now. So those types of visas, I think, are going to see a lot of tumultuous activity in the coming months.
Yeah, I mean, we've heard all about it on the news. From a tax perspective, a couple of points to make here. So there was an executive order talking about looking at the U.S.-China tax treaty, the income tax treaty, and potentially eliminating that or vitiating that. That is still an ongoing, I think, review process. But if they do vitiate that, that'll create some interesting tax consequences that folks from China need to be aware of. From just a pure income tax perspective, with the F visa, generally you have 5 years that your days are exempt from counting under the substantial presence test. When I say that, it sounds very straightforward and simple, but trust me when I say it's anything but simple. And there's also a lot of F1s that do OPT, and you really have to ask the F1 about when did you really come to the United States, because sometimes they'll talk about, my college experience, but you don't realize that they were on the F1 back, they came for high school and they have been here for like 20 years. And so for tax practitioners dealing with F1s, make sure you really get your facts and circumstances in alignment. With the J and M visa, I believe it's 2 years and your days don't count for purposes of the substantial presence test. We represent a lot of J visa holders that are teachers from foreign countries. that will come teach at various universities in the Virginia, Maryland, DC area. And the biggest issue there is not the federal income tax, but rather the state income tax, because states don't abide by the treaties. And then lastly, I just wanted to add some levity to the conversation today. My favorite client of all time was actually an M visa holder. And they were a fighter pilot from a foreign country that had come to the United States to train in San Diego. I think at the top, I think it was maybe it's Top Gun or something similar to Top Gun. But just hearing them talk about, getting the M visa and kind of coming in and being able to do that here, I think was really cool. So anyway, back to you. Do you want to go into the H-1B and L and O visas?
Sure. So the types of visas that we see a lot of in our business immigration practice are the H-1B, which is sort of the basic professional worker visa for people with degreed professional workers. There's also the E3, which is basically an H-1B, but for Australians. And then there's the H-1B1, which is basically an H-1B, but for Chileans or Singaporeans. And so those special visas, the E3 and the H-1B1, are treaty-based visas. So they're essentially the same as the H-1B, but they have sort of special provisions under the treaties with those countries. I don't know, Mish, if they have any special tax treatment, the E3 or the H-1B1, but they definitely have some special immigration provisions.
Yeah, well, I always tell people on those types of visas, actually, the world's your oyster, because there is a savings clause that in all U.S. income tax treaties, where if you're a green card or U.S. citizen, there's a limitation. The savings clause kicks in; it limits your ability to use the treaty. But in some cases, depending on the facts and circumstances, again, it's not applicable to all those people. But in some cases, they may have access to a good portion of the treaty, and may not, savings clause may not trigger for them, and so that there could be a better outcome. And it typically occurs when they come inbound or outbound of the United States for that first year, that last year.
Cool. So the HLO visas are sort of like the bread and butter of business immigration visas. The H-1B, you might have heard of the H-1B lottery. That happens every year at the end of March, beginning of April. There are usually about 3 times as many people who want H-1B visas as are available. So those lucky 30% of people who get selected in the H-1B lottery can apply. We're working on those cases now. So sort of the annual cycle is apply in March, or apply for the lottery in March. If you're selected in the lottery, then you file your petition over the summer. If your petition is approved, you can start your H-1B on October 1st. So those are what are called cap subject H-1Bs, which are sort of the majority of first-time H-1Bs. And then there are people who already get a cap subject H-1B who want to move to a different employer or extend it. And there are cap exempt H-1Bs. So you mentioned that you work with universities. If universities want to sponsor someone for an H-1B, they don't have to participate in this lottery. So cap subject and cap exempt H-1B are by far the biggest category of working visas for temporary workers in the U.S.
And since they are working visas, you don't need an employment authorization card, right? Like a G4 spouse would need to get an EAD to be able to work, but these people are not required to get that.
Correct. There are very limited circumstances under which the spouse of an H-1B, which is an H-4, so an H-4 is an H-1B spouse. There are very limited circumstances under which that person can get an EAD, but otherwise, no. The principal H-1B does not need an employment authorization document. Okay. So the next category is the L1, which is an intercompany transferee. So if you're a manager or a specialist with a multinational company like Microsoft or Amazon or smaller companies, then you could be transferred to the US. That category is really nice because it does include automatic spousal work authorization. So if your spouse comes with you into the United States, your spouse will immediately be authorized to work. And that's the same for the E1 and E2 categories. So your spouse will get work authorization. They can get an EAD, but under current law, they don't need an EAD to start working. So that's a nice benefit of those visas.
That's fantastic. Just for the audience to understand, so on these types of visas, you are subject to the substantial presence test. So you can become a tax resident. I think what Becki said earlier, though, is that these folks don't have any requirement to stay inside the United States, so they could be non-residents for U.S. tax purposes, depending on the amount of time. But if you do trigger the substantial presence test, you're fully taxable. You also need to look into your state tax rules to see if you trigger state tax residency there as well. I believe one of the big differences between the H and the L visa and the O visa is that FICA is taxable to H and L, but not to O. So there's a little bit of a nuance there for the O visas that you got to be careful with from a tax perspective. And then one more thing before we move on. I think I misspoke earlier about the J and M visas. You get 5 years under both of those, just like the F. There's a special provision, I think, for certain scholars where it's 2 years for the substantial presence test. So apologies for misstating that.
Tax law is complicated.
It's very complicated.
So the O1 is the last sort of working visa that I wanted to talk about in that group. And we talked earlier about green cards for aliens of extraordinary ability. Aliens is not my word, it's in the statute. And the O1 is the temporary visa for aliens of extraordinary ability. So some people call it the artist visa. Some people call it the Einstein visa. Immigration lawyers just usually call it the extraordinary ability visa. And it's for people who, if you are an artist, so a visual artist, but also, someone who works in a creative field, you have to show that you're distinguished in your field. If you're a business person or scientist, you have to show that you're among the handful of those at the top of your field worldwide. So very high standard for business people and scientists, but easier to get for people in the creative disciplines.
Yeah, we have a family friend where we live that he's a doctor on an O1 visa, specialist at a very prestigious hospital here. And, when he told me he's on the O1 visa, you kind of like, wow, okay, you must be a big deal.
He's probably pretty impressive.
Yes, no, he is a very impressive person, but it's having known that, I was just like, wow, you're kind of like, oh, you're like a rock star almost. Yeah,
exactly.
I want to move on because we're going to run out of time here, but there's two more topics I want to briefly talk about. The first, and I'm just trying to get some thoughts here from you, Becki. You may or may not have any, but first topic I want to talk about is this proposed excise tax. And I had to double check it today because I saw a letter from the banks are freaking out. U.S. banks are freaking out left, right, and center on this. They refer to it as a 3.5% tax, but I looked at the bill and it says 5%. So maybe I'm not reading it right, but 5%, and basically it's an excise tax. It's called a remittance transfer, meaning that if you're a non-citizen or non-national and you're transferring money from inside the United States to outside the United States, whether it's through your bank or some other financial institution, I have questions like, what about my pension? What about my World Bank pension? You would pay potentially under the House tax bill, you'd pay a 5% excise tax on any of those transfers because you're not a citizen, you're not a national. And one of the big things about the article I read today was in order to get around the 5% tax, if you're a U.S. citizen. So, for example, if I'm a U.S. citizen, right? And if I want to say send money to a bank account in the United Kingdom, maybe it's my own bank account. How would I prove to the bank that I'm a U.S. citizen? Would I have to bring my birth certificate there? I mean, how do you prove you're a U.S. citizen? Is it so one, I have a question about that. Number two, what do you think about this law? I honestly, just being Nostradamus for a second, looking in the crystal ball, I'm not certain it's going to come out in the Senate version. I don't think they're going to try to kick it out because it raises revenue, and they're looking for anything to raise revenue to pass that bill. So I think unfortunately this one's going to stick in there. I'm hoping not. But what do you think? And then tell me about how to prove I'm a U.S. citizen.
Okay, well, maybe I'll start with how to prove you're a U.S. citizen, because that's under current law, that's not too hard. So a U.S. birth certificate or a U.S. passport would typically prove that you're a U.S. citizen. So when you started working for the Wolf Group, they probably completed a Form I-9 for you. It's a form that all U.S. employers are required to complete for all employees, including U.S. citizens. And so you have to provide documents to show that you're authorized to work in the U.S., which could be proof of U.S. citizenship, proof that you're a permanent resident, or proof that you're a temporary worker authorized to work in the U.S. And so typically the documents that a U.S. citizen will present would be a passport or a driver's license and social security card, which I think in the context that you're talking about probably wouldn't be sufficient, or a birth certificate and an identity document. So I think in this context, probably a birth certificate or U.S. passport would be what they're looking for. I will share that the birthright citizenship case that
Yes.
is in the Supreme Court. So when this administration came into the White House, they created an executive order eliminating the birthright citizenship provisions, which are in our Constitution. And that went to the Supreme Court. Surprisingly, what was recently litigated in the Supreme Court was not whether they were or should be able to overrule the Constitution by executive order, but rather the administration was asking the court. So there were 3 intermediate courts that ruled that executive order unconstitutional.
Okay.
And the administration wanted the Supreme Court to limit that restriction to those 3 jurisdictions. So what that would mean is that if you were born after the date of the Supreme Court decision in one of those 3 jurisdictions, you would be a U.S. citizen. If you were born in any other jurisdiction in the United States, your citizenship would be determined by other factors. Now, imagine the burden that would place on
My
employers.
goodness.
It's hard enough right now for employers to understand whether someone's a U.S. citizen. I mean, you're asking me, how do you prove someone's a U.S. citizen, right? Like, I think most people don't even necessarily know the answer to that question. But now the administration is asking that we make it inordinately complicated and basically ask employers to engage in a legal analysis. Hospitals, I mean, all sorts of businesses would have to try to understand Supreme Court case law in order to figure out whether someone's a U.S. citizen. So that's a bit of a tangent, but I think, may be relevant to what we're talking about.
No, highly relevant. Thank you for that update. Going back for a second, though. So I was born in Wisconsin, for example. How do I get my birth certificate if I don't have a copy of it?
So there should be a vital statistics organization in Wisconsin, like maybe the Wisconsin Department of Public Health, that will keep a record of your birth certificate. There are also third-party websites that you can go to. So I think if you Googled order a copy of my Wisconsin birth certificate, you would be able to go to the Wisconsin Department of Public Health to retrieve a copy of your birth certificate. And probably a good idea for everybody to have a certified copy of their birth certificate.
Yeah, I can already tell you my wife's going to kill me because I'm going to come out of this because my wife handles everything. I'm typical. I don't know what's happening. So I'm going to come out and be like, where's my social security card? Where's my birth certificate? I know she's got my passport because I know where that's at. But I really don't think I know where any of the rest of that stuff is at. All right, real quick. Any comments on the remittance transfer tax before we move on to the last little tidbit?
Yeah, so I have to admit, I haven't studied it in detail. It definitely doesn't surprise me. I mean, not only in terms of revenue generation, but in terms of the sort of motivation of this administration to keep money in the country. I think a lot of the people who make remittances, and I don't know how much they're targeting this group, but are undocumented people or documented people who are foreign nationals who are sending money back to their home countries. So I suspect that might be at least part of the motivation behind this provision, maybe not all of it.
Yeah, I would say anyone that's a non-citizen or non-national, and whenever I think national, I'm thinking America, Samoa, although maybe you have a better definition for me than that. But anyone that's not one of those 2 categories, this could apply to you. So I'm talking to you green card holders. I'm talking to you G4s. I'm talking to you H-1B-O, all you folks, L1s, everyone, EB. Well, I guess the EBs wouldn't really count for them. Well, no, they actually would count for them. But be real careful and think through, because it's for transfers from inside the U.S. to outside the U.S., not the other way around. So you can send as much money as you want inside the U.S., no problem on our side. Now, maybe you've got fly to capital rules or issues from your foreign country, but the other way around seems like that could be an issue. Okay, last comment that I want to make, because we are talking about crossing borders here and issues crossing borders. And we've seen a lot of this lately here at the Wolf Group. There's Internal Revenue Code 7345, which is part of the PATH Act, which I believe is the last thing the Obama administration did. But basically says that if you have a certain amount of income tax due to the IRS and you haven't gotten into a payment alternative, meaning you're not promise to pay or installment agreement or offer in compromise. It's just a debt that's outstanding and the IRS is actively trying to collect for you. That limit was set at $50,000 indexed for inflation. I believe for 2025, it's $64,000. But if you have that, and we see that a lot with people living offshore because they don't even know they owe the debt. They haven't filed, like you talked about earlier. The IRS has gone in and filed for them. They've created the debt. They haven't been able to get in touch with the person. The person now wants to come back into the United States. And under this law, because they owe so much, the IRS has sent a note to the Secretary of State and they put a kind of hold on the passport. And if you try to come back inbound into the United States and you have that hold there, they'll take you into that secondary protocol and they'll make you get into a collection alternative with the IRS before you can enter inside the United States, which is very difficult to do over a phone of that magnitude. Typically, the IRS is going to want you to give them information about all, your blood type down to your firstborn child to be able to get into that kind of alternative. So we try to solve that before they even come back in. We try to identify that. You can look that up and you can do some kind of discovery with the IRS to make sure the person is in full compliance and doesn't have any 7345 issues. But any commentary on that before we go on to the last little tidbit?
We have seen that happen in our practice, but honestly, that's another situation where we would call the wolf group if that were to occur.
All right. Yeah. If you have an issue with that, let us know. Okay. So Becki, last question for you. If people are listening to this and they want to get in touch with you, they want to get a consultation or have a discovery. I don't even know how you offer any of those things, but they have an issue and they want you to help them solve it from an immigration standpoint. How do they get in contact with you? What does that look like? What paperwork should they prepare, generally speaking? Give us the elevator speech you would normally give to someone interested in your services.
Sure. So we can definitely consult with anyone who has questions that were raised by the conversation in this podcast or otherwise has questions about U.S. immigration. I love to, normally the type of work that I do is helping employers bring employees to the U.S. to work here legally and stay here legally and get green cards. So I love receiving those kinds of inquiries these days. That we get a lot more inquiries about people who want outbound immigration or are concerned about re-entering the U.S. But our firm is kind of unique in that we offer all types of U.S. immigration services as well as outbound services. And so, if folks do have questions and want to consult, they should feel free to reach out to me. The firm's name is Grossman Young and Hammond. And if you Google it, you can get to our website. My email's on there. It's byoung@grossmanyoung.com. And so folks should feel free to reach out if they would like to have a consultation.
And we're going to put all that in the show notes, folks. So if you want to find it on there, it'll be in the show notes. Becki, thank you so much for coming on. I'm hoping to do just one podcast on the gold card should that ever come into being. And maybe if I'm lucky enough, you'll come back on and give us all the details about that. But
Absolutely.
Thank you so much for coming on today. We really appreciate it.
It was my pleasure. Have a great day.
You've been tuning in to the Essential Tax Podcast with your host, Mishkin Santa. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcast, Spotify, and on our website, thewolfgroup.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.